All attendees are in listen-only mode.
Good afternoon, everyone. This is Chris Frine of Percentra Group. Thank you for joining us today, Thursday, February 12th, for a webinar on sexual harassment in the workplace. Our webinar today is scheduled to run approximately 50 minutes, and we will have some time at the end for questions. Chris Brown of Percentual HR is going to be leading us through this topic today. As always, we'll post a copy of this recorded webinar, as well as any slides that Chris presents, onto the Client Resource Center shortly after today's session. We do have quite a few participants on this webinar, so we ask if you do have any questions, please enter them in the questions dialog box, and we'll present those to Chris at the end of the session. Also, today's webinar has been approved for one general HRCI recertification credit toward PHR, SPHR, and GPHR recertification through the HR Certification Institute. We'll be sending out an email shortly after the webinar to all participants with that code. So at this time, I'll turn it over to Chris Brown to get us started for today. Chris?
Thanks, Chris. So, today's topic is on sexual harassment, which is not, a new topic. It's been something that employers have been concerned about for a couple of decades now. But we still get lots and lots of questions on sexual harassment. And these days, I tend to frame sort of workplace harassment as workplace harassment, and we need to prevent all forms of harassment and all forms of discrimination. But sexual harassment is certainly one of the more common concerns for employers because of the prevalence and because of the impact that it can have on the workplace. So we'll be talking about that during our webinar today, and of course, happy to answer any questions that spring off of that. So let's just get started. What I actually did, I was trying to decide the best way to present this, and I kind of thought that, let's just look at it from the context of an anti-harassment policy. So we're actually going to start off by looking at the components that we include in our anti-harassment policy, our sexual harassment policy, and talk about what all of that is and why an employer needs to be concerned about that, and maybe it can provide some insight into how you structure your policies. So sexual harassment, as we know, is a particular form of harassment, and harassment can occur in so many different ways: age, religion, national origin, citizenship status, disability. There's all kinds of harassment, but sexual harassment is a particular type of a subset of harassment that's based on sex. And under federal law, we have two forms of sexual harassment. The first form of sexual harassment, and I guess what you might consider the stereotypical form of sexual harassment, I used to call it the 1980s version of sexual harassment because there were all these movies in the late 80s and early 90s where there was about sexual harassment in the workplace, is the quid pro quo form of harassment. And as many of you probably know, quid pro quo is just a Latin phrase which essentially means this for that, and it is effectively any time anyone offers to do something in exchange for something else, that is quid pro quo. Now, in the context of sexual harassment, it is when someone is coerced, forced, or incentivized to engage in some sort of sexual conduct as a condition of employment. And so it can be a condition of initial employment. So you could, for example, have a recruiter who engages in quid pro quo harassment for someone to get a job. It can be related to ongoing employment, where a manager or supervisor demands things of an employee in order for them to keep their job or get a promotion or get more favorable treatment at work or whatever the case might be. But the primary thing that we see in quid pro quo harassment is there has to be some sort of power differential between the harasser and the complainant. So you will not generally see quid pro quo harassment in the context of two employees. It's generally an employee and a supervisor or a manager, or there's some power differential where one person has the ability to impact the ongoing employment or future employment of the person who's being harassed. And that's a central factor in quid pro quo harassment. This, of course, is one of the reasons why so many companies attempt to discourage and some even attempt to prohibit, although your ability to prohibit off-duty contact is practically non-existent. But this is one of the reasons that employers so often attempt to prevent any sort of romantic involvement between managers and subordinate employees. And the reason for that is because of the fact that the manager has this direct control or influence over the employment of that individual, it greatly increases the exposure to the firm of an argument of quid pro quo harassment. And so that's why some companies have gone so far as to require that if a manager engages in any kind of relationship with an employee, that it's declared and that they interview the employee and make sure it's consensual and that there's no quid pro quo or anything like that. But even if you do all of that, it can still come back and bite you. But in reality, you can't really prevent your employees from having off-duty relationships with other employees, as much as we might like employers to do that. And I see non-fraternization policies all the time where employers are trying to find some way of accomplishing that, and in real life, it just doesn't hold up. What people do outside of work is pretty much entirely up to them. The other type of sexual harassment claim is the hostile work environment claim. And a hostile work environment claim covers a much broader set of behaviors, and it's open to a much broader array of offenders. So we can easily have a hostile work environment claim where one employee feels harassed by another employee, or a vendor, or a customer, or anyone else who is on your premises. So that type of claim is actually the one that we see as a larger problem today, because by and in large part, the quid pro quo stuff, people have figured out they're not supposed to do that. Now, that doesn't mean people don't do it, and we're going to give you some examples. But the hostile work environment is much more difficult to control, and the reason it's much more difficult to control is because we have a much broader array of potential offenders and a huge array of behaviors that can constitute harassment. And so that is an area that we focus a lot of training on, is how do we identify situations that could constitute a hostile work environment and preemptively stop that behavior before it becomes a problem. Because as an employer, we have an obligation to prevent harassment, not just to respond when harassment has been reported. And so if I'm a supervisor or a manager or whomever, and I observe that there's some behavior or some actions that could constitute a hostile work environment, the employer has an obligation to stop that, even if no one has complained. So if I go into the shop and I see that a bunch of the employees are standing around a computer watching pornography, and I just sit, nobody seems to be upset. They all seem to be, I don't want to make it sound bad, but everybody seems happy. No one's complaining about it. I can't just be like, oh, well, no big deal. That's no problem because no one's complained. I have to stop it. I have to stop it immediately. I cannot allow that behavior to continue simply because no one has registered a complaint, because I have an affirmative duty to prevent a hostile work environment, even if there has been no complaint. And pornography is kind of an extreme example. We could have catcalling, we could have jokes, we could have just people who are using inappropriate language in the workplace. There are all sorts of behaviors that could create a hostile work environment. It's sort of almost the sky's the limit. And so we need to train our managers and supervisors that when they recognize that behavior, that they need to stop it even without a complaint. So here are some examples, and once again, this is just like from a policy standpoint, what we would include in a policy. So it's verbal or physical, includes but not limited to any conduct of a sexual nature or suggestion which is unwelcome and which unreasonably interferes with an individual's job performance. The key word here is unwelcome. It doesn't rise to the level of sexual harassment until it's unwelcome. which is why people ask, well, if all the guys in the shop are okay watching that video, then clearly it's not unwelcome, so what do we have to be concerned about? Well, here's the problem. How do you know that it's unwelcome or welcome? Rather, we know when something's unwelcome because someone will often complain, but we don't know that the reverse is necessarily true. So if I go into the shop and I see 10 guys and this video's playing, I might assume that because nobody is running to me and telling me that the behavior is unwelcome, that it's all okay, but that isn't necessarily the truth. And there are substantial number of cases where an employer made the assumption that employees were okay with some behavior because no one had complained, and therefore they didn't feel that it rose to the level of sexual harassment, but it turned out that there was somebody who wasn't happy about that behavior. So don't get too hung up on the unwelcome aspect of that. Or any behavior that implies or threatening adverse employment action if sexual favors are not granted. So this is the quid pro quo form of harassment. Any sexual language, propositions, or innuendos, obscene or suggestive jokes, language, or gestures, that all can constitute sexual harassment. Comments, jokes, remarks, or utterances about gender-specific traits, whether directed at an individual or members of a gender in general. There have been lots of examples where someone didn't necessarily target a specific person, but they just made comments about all women are this, or all men are this, or women can't do this, or they referred to one gender in a derogatory way. So it doesn't even have to be directed at any specific person. It could just be general in nature, and it could still create a hostile work environment and therefore a liability for the employer. So there really are just a ton of ways that this can occur, and we just need to always be on the lookout for it. Any display of sexually explicit or suggestive print or visual material. This is why we sometimes go through shop and look for any obvious material that shouldn't be there. There used to be a lot of tool companies that would distribute calendars and posters and things like that that could most certainly constitute a hostile work environment. And so that's definitely something that we need to be on the lookout for. Most employers have gotten better about that. Offensive remarks or unwelcome comments about a person's appearance. And once again, we don't know if it's unwelcome, so we have to presume that it isn't. Maybe one of your employees likes walking through the factory and getting a bunch of catcalls from the workers, but maybe they don't. You don't really know. And so we have to assume that the behavior is unwelcome and stop it, even if perhaps that particular employee doesn't have a problem with that behavior. So I mean, I get a lot of employers who get hung up, I think, on this, well, this employee was okay with it, so why is it a problem? Well, we really don't know, and they can be okay with it one day and not be okay with it another day. And that's why we have to assume that if it crosses a certain threshold, it's unwelcome. Now, on the flip side, I'll have employers call me up, and they'll say that, I have an employee who complains because another employee talks to them. And they feel that the way they talk to them is a hostile work environment. And we'll try and, well, how are they talking to them? Are they screaming? Are they, what are they doing? And really what it boils down to is you've got an employee who just doesn't like another employee, and so they don't think that employee should ever be allowed to speak to them. Well, that doesn't rise to the level of harassment. Just because it's unwelcome doesn't mean that it rises to the level of harassment. So, it kind of goes both ways. You can have some people who welcome harassing behavior, and you can have other people who are offended by non-harassing behavior. We have to deal with all those circumstances. Spreading stories or asking questions about a person's sexual conduct, leering or staring at a person's body. This one we comes up a lot. When is it leering or staring? I guess it can be a subjective thing. We've certainly dealt with many situations where an employee felt that someone else was staring at them or making faces at them or doing something inappropriate in the way they looked at them, and we talked to the other employee and they didn't even realize they were doing it. I had one where this guy had a vision problem, and another employee was complaining that they were always staring, that the guy was always staring at her, and she never realized that this guy had a vision impairment and he couldn't even see that far. It was because of his vision impairment that he looked the way he looked. So, sometimes there can be misunderstandings here, and we always have to investigate these situations to figure out what's actually going on. We can't just fire somebody because someone complained. Sexual stereotyping. We've seen a lot of cases where an employee was tormented or subjected to harassment because they didn't meet some gender stereotype. They weren't strong enough to be a man, or they didn't look feminine enough to be a woman, or their voice was wrong, or this is another form of sexual harassment. Any harassment or other unequal treatment of an employee or a group of employees that would not have occurred but for the gender of that employer or employees may constitute sexual harassment if that harassment or other unequal treatment is sufficiently serious or pervasive to create a hostile work environment. So this is kind of covering the bases of what is harassment. And like I said, I actually just took that out of our anti-harassment policy because I thought, hey, what a great way to talk about this topic of, what do we want to cover in the policy. The next thing that we always want to do then is encourage, and encourage is maybe too light of a word. We basically want to require employees to report harassment to us. So anybody who believes that they've been the victim of harassment or believe that they've witnessed this harassment, so even if they weren't the victim, if they just observed the harassment, they need to immediately contact their supervisor, the Director of Human Resources, or any other member of management. Now, one of the problems that we see in a lot of sexual harassment policies is that they just say, talk to your supervisor. That is never going to cut it. You always have to give them other ways of reporting the harassment, because very frequently the supervisor is aware of the harassment and hasn't done anything about it. They might have too much interpersonal stuff with the person who's making the complaint or the person who allegedly was harassing to really look at it objectively. And so because of that, we cannot just rely upon a supervisor as being the point of contact. Sure, they can complain to their supervisor, but they need to have other options. And so in our policy, we say Director of HR, any other member of management. For a lot of companies, we might designate specific individuals who an employee can go to if they feel that they've been harassed. Often it's good if we make sure that there are individuals that are both male and female, because you wouldn't want, for example, a female employee to have the only option of reporting harassment to be male managers who they might feel uncomfortable talking to. I've seen some companies who, I think in very good faith, had a policy that was something along the lines of, immediately report this to the general manager or the president or CEO or something like that. I think that's going too far, because if you've got a brand new employee who's at the bottom of the org chart, are they really going to feel comfortable, if they get harassed on the first day of the job, running to the president of the company? Probably not. So we need to give them lots of options. Some companies, and we've worked with companies and done this, they want to establish like a special phone number where it can go to an outside party to report harassment. Now, there are some additional complications that come up with that, but what that company is trying to do is they're trying to make sure that that employee has every opportunity in the world to report that the harassment has taken place, because this forms an important part of our defense if we end up in court. If we train employees, if we have a good policy, if we tell them how to report harassment and they don't do it, then it's very difficult for them to sue us. I don't want to say impossible, but it's extremely difficult for them to sue us if they didn't avail themselves of the mechanisms and opportunities that we had put in place for them to report this conduct. And so this becomes a very important part of your defense as an employer, is making certain that all employees are aware of how to identify and report harassment. How are we going to enforce our anti-harassment policy? Well, we're going to investigate. If something has occurred, we're going to look into it and we're going to discipline anybody. We're going to try and keep everything confidential, but we can't guarantee it. If you were in on our webinar last month on workplace investigations, a lot of times you will have employees who will have this expectation that they can report harassment and have like total anonymity. No one's going to know that they reported harassment. And I guess I said that kind of mockingly because to me it seems totally absurd. How can we investigate a case of harassment if we can't disclose who was harassed? And so we need to let employees know that we're going to do our best to keep things confidential, but we can't guarantee that no one's going to find out that you made this complaint because we have a legal obligation to investigate it. And I've been involved in many situations where an employee reported harassment but they didn't want the employer to do anything about it. That isn't an option. Once the employee reports harassment, the employer has a duty to investigate and take action. And if the harassment was really bad, they may have to fire the offending employee, even if the person who was harassed doesn't want them to be fired. And this is sometimes a problem that we run into with businesses, is that they've got an employee who reported some behavior. Now they feel bad. They really don't want the other person to suffer any adverse consequences. Well, I'm sorry. Once we're aware of the harassment, if we investigate and determine that it took place, and in particular if it was serious, we are going to have to take action. We cannot ignore it. That is not an option for us. So, from the standpoint of, employer liability, the employer cannot simply ignore harassment, even if the employee who complains, says, "Oh no, I'm okay with it. I really don't want to, pursue this." It doesn't matter. Once it's been reported, we have to act. So let's just, I've got a couple of cases in here that we can look at, and the cases are just illustrative to give you an idea of what's going on out there. These are recent cases, and we could find virtually any kind of sexual harassment case we want. There's been so many of them, but here's just some recent ones. Now this was an interesting one because this is really more sex discrimination than sex harassment, but they kind of all fall under the same umbrella. So this was Ruby Tuesdays. They were sued by the EEOC, and the reason they were sued is because they restricted certain assignments to female employees. So it was basically sex-based discrimination, and I like to use examples like this because who were they discriminating against? They were discriminating against males, and oftentimes employers will sort of mistakenly believe that, well, we only have to worry about discrimination and harassment in regards to our female employees. Those guys, they can just take whatever comes their way. We just have to protect the women, and that's not true. In this case, they posted an internal announcement within like the entire, Mountain West, that they were going to be putting people in summer positions in Park City, Utah, and the company was providing housing. So, I mean, who wouldn't like to go to Park City? Park City is beautiful in the summer, and so they were giving this this opportunity, but only to women. Now, they felt that they had a reason to do this because they believed that, oh gosh, if we have to house men and women, then we've got all this liability, and so we believe that we've got a legit business necessity in limiting this opportunity to women. Well, the EEOC disagreed. And so this is an example, and I like to use these just because they're not what people tend to think of an example where an employer discriminated on the basis of gender, but they discriminated against men, which is the opposite of what most employers are paying attention to. They're usually worried about discriminating against women. And there have been a number of cases like this. There have been some that have been unsuccessful. Many of you probably heard of the case against the Hooters restaurant chain probably 10 or 15 years ago now, where a male wanted to be a server and ultimately The restaurant chain prevailed because they were able to demonstrate that, female-only servers were a business necessity. I honestly don't know if they would win that case again today. If somebody wanted to relitigate that, it could have a very different outcome. But 10 or 15 years ago, they barely got by. But there are plenty of examples of companies that weren't able to do that. Now, here's another recent case. This was a Detroit-based automotive accessory chain. Had to pay $20,000. So not a huge settlement. I mean, we can point to gigantic ones, and we've got some examples of larger ones in here as well, but I just like to illustrate a broader way. In this case, it was a female employee who was subjected to a hostile work environment by a male employee. The employee reported the harassment and then was retaliated against, and you're always going to lose, all right? If you've got somebody who reports harassment and you don't do anything about it, and then you allow anything bad to happen to that employee, even if maybe you didn't intend it to be retaliation, it's going to be very bad for your business. And so we've seen some examples for where and a classic one comes to mind. They had a female employee who was being harassed by a male employee, and they were, the company didn't really want to get rid of the male employee. It was kind of a he said, she said thing. They weren't really sure exactly what happened or the extent of it, and so they thought that they needed to separate these employees. So, hey, easy solution, let's separate the employees. The problem is the way they separated the employees, effectively the female employee, and I don't remember if I think she got moved to a different location that was further from where she lived. Maybe the schedule was different, but effectively, she suffered adverse employment action as a result of this separation. And so ultimately when it went to trial, it was viewed as retaliation. The employer hadn't, I don't think the employer intended it as retaliation. I mean, who knows, maybe they did. I think the employer just did a lousy job, and they didn't think about the fact that making this change could appear retaliatory, and so they lost. If we look at the data on harassment claims, and this is EEOC data, one thing that you can see is if we go back to the 1990s here, and this is just the most recent chart we could find, we can see that the number of complaints to the EEOC has been going down. What you can also see, though, so we have 15,889 here in 1997, and it went down, it was pretty steady for a few years, and then it's been going down steadily since to 11,364 in fiscal year 2011, and I don't know, they don't have a chart that's more recent than this. What's interesting, though, a couple of things that are interesting. One, the percentage of charges from male employees has been steadily going up. So even though the number of complaints has been going down, the percentage of those complaints from male employees has been going up, which is interesting because a lot of employers, as I mentioned earlier, don't ever think about harassment of their male employees. And I'm not just saying this because I'm a guy, I'm just saying it because I've just seen this trend, that we see more and more cases where male employees are making complaints of harassment, and the employer just dismisses it because it's, oh, you're a guy, you should be able to handle it. In particular, many of these cases were not, and this is important, many of these cases were not where females were harassing these male employees. They were being harassed by other male employees. And so same-sex harassment claims have become a much bigger issue than they were years ago. And I think we have an example in here of a same-sex harassment claims. So then they kind of break down these numbers a little bit more. None of the rest of this is real exciting. One thing that you'll see is that that only a relatively small percentage are settled by the EEOC. So sometimes that's because the EEOC finds that there wasn't really there was like no reasonable cause. So like you see that like roughly half of the complaints after the EEOC investigates, they find that they're, hey, this wasn't really harassment, it was just an employee complaining or whatever. But, a lot of them do get settled. Now this is just EEOC. This doesn't count stuff that the EEOC So like these monetary benefits down here that look relatively small, 52 million in 2011, that's just stuff the EEOC collected. That isn't lawsuits. Okay, now if the EEOC was involved in the lawsuit, maybe, but the EEOC only becomes directly involved in a relatively small percentage of the cases. In most circumstances, they just will attempt to help resolve it. If it can't be resolved, then they might issue what's called a right to sue letter, which gives the complaining employee clearance to pursue the case in court, at which point they would then have to go and find their own attorney, and then we start to often see much larger damages because of the fact that it's going to trial and it's no longer just a administrative action by the EEOC. So how do we prevent all this harassment? Well, we've got to continually provide harassment training to our employees and our supervisors. The training aspect is one of the biggest things that just employers are doing a lousy job at. Some employers have never provided any training at all. Some employers only provided training, when they first hired people, or they just provide training sort of sporadically. So you've got some employees who should never be trained. And one of the first things when you onboard a new employee is the harassment training, because they could literally be harassed as soon as they walk out of the HR office. Heck, they could have been harassed in the HR office. So we want to get this harassment training day one. Okay? Fill out your I-9 form, now sit down for harassment training. That's really a best practice, because we don't want to put an employee out there in our facility who isn't aware, for example, of how to report harassment. That's a big liability to us as an organization. So that's something that we really need to look out for. And then we also need to constantly train our supervisors. How do you recognize harassment? How do you respond even when there isn't a complaint? Because remember, we can't just wait till somebody complains. We've got to be proactive about this. We've got to prevent the harassment from occurring. How do we, I was talking about supervisors. How do we as supervisors respond when an employee makes a complaint so that we're not minimizing it? How do we move it up the chain so that it's investigated properly? There's a lot of things that the supervisors have to constantly be reminded of. And I think that all employees should be required to go through harassment training annually, because I think it's a really good risk management strategy for the employer. We want to have a good harassment policy. We were just talking about a policy. We want to have a good disciplinary action policy that gives us lots of tools to deal with misconduct. And what I mean by lots of tools is that if we don't have an array of tools for dealing with disciplinary problems, and our only option is to let someone continue doing whatever bad thing is they're doing or fire them, then we're going to have problems. All right, we need to have, sometimes people are suspended for a day without pay. Sometimes they, there's a whole array of things. Sometimes it's just a warning because what they did wasn't really that bad, We need to have a whole array of tools to deal with these kind of things. And the most important strategy is to take action before a complaint. Do not wait until someone complains. If you are aware of behavior that could create a hostile work environment, you're going to take action to stop that behavior immediately, as soon as you are made aware of it. You are not going to wait around for somebody to complain, because if we wait around for somebody to complain, then we are going to have a problem, because at that point the damage may be so bad that it's very difficult for us to do anything about it. So we definitely want to take action as soon as we're made aware of any circumstance that could constitute sexual harassment. We have to investigate. Now, last month our webinar was all about investigations, but just as a few reminders, we need to conduct a thorough and impartial investigation. This is why supervisors often take a back seat in these investigations, because it's very difficult for a supervisor to be impartial, because they may work with these people every day. They may like one of them more than the other employee. We are humans. We have, favorites. It's just life. So that's why I just am not a big fan of supervisors playing a major role in sexual harassment investigations, because they're too close. It's very difficult for them to be objective. We want to keep everything we learn as confidential as possible, but we can't guarantee full confidentiality, and that is just something everyone needs to be aware of up front, that in order for us to investigate this, we're going to have to be able to talk about what happened, and I'm sorry, we're going to try and do it as well as we can to keep this information confidential, but there's no guarantees. Other employees will probably find out that there was a sexual harassment claim simply because we've got to go and talk to people and find out what actually happened. So, I mean, sometimes you don't have to do that, but oftentimes you do. And you certainly almost always are going to have to notify the accused, because how are you going to sit down and talk to them about, this incident if you can't tell them who reported it? They need to know, who's accusing them of harassment. Now, last month in our webinar on investigations, conducting workplace investigations, we showed you a lot of forms. I'm not going to spend a ton of time going over those again, but if you'd like to use some of these documents, we've got a whole set of documents that can help you investigate harassment, how to have a good complaint process, and how to handle investigations, taking statements from employees, taking statements from witnesses, how do we train our supervisors. We've got a whole kit, and this can provide you with some tools to kind of help you with your own processes internally when you have to deal with this stuff, which hopefully you don't have to deal with all that often. Now, the employee does have some responsibility here, okay, and that's one of the reasons that we conduct the training, because the employee has got some responsibilities. So the first responsibility is they've got to take reasonable steps to avoid the harassment. So if they've got some other employee who is touching them inappropriately all the time, then they should remove themselves from that situation. Now, they can't, obviously they're going to have to tell somebody why they have had to do that, but they're supposed to take reasonable steps to avoid the harassment. So they can't just hang out in the area and, continually be harassed. We can also require them to file a complaint, and that's one of the things that obligation is transferred to them in our training. We are going to make sure that they are aware that they are obligated to file a complaint if they witness harassment or if they are harassed themselves. And we're also going to ask them to, hey, confront the harasser and let them know that it's unwanted. A lot of times the problem is solved right here. All right, I mean, I've had a lot of situations where somebody was just offended by the way someone referred to them, or something that, to the employee who was the accused employee didn't even really realize it was a big deal. And I think one of the greatest examples of this is that my grandfather used to always refer to women as gals, G-A-L, because he was just an old guy, and that's just, he'd never thought anything of it. And about 20 years ago, we had to have a sit down with him and say, you've got to stop doing that in the workplace. It's not okay. You cannot, you just can't. Somebody's going to take offense to it, and it took him a long time to change that behavior. And there was never any specific complaint, but it was just something that was an exposure that was out there, and he just didn't even think about it. To him, it was just second nature. It's just what he said. And sometimes that's the case. Sometimes it's not the case. EEOC will protect employees who are trying to file a complaint, particularly if there's retaliation, like they're fired, demoted, or subjected to further harassment. I mentioned earlier that same-sex discrimination cases are becoming increasingly common and are a big concern because of the fact that sometimes employers will just incorrectly assume that, hey, it's all guys out on the job site, so I don't have to think about it. So I've got an example here of a construction site where you had an employee who was harassed by their supervisor because he didn't meet the supervisor's gender stereotype. And so this is becoming an increasingly problematic type of harassment, because a lot of these businesses that maybe, and you always have to ask yourself, why is it all guys, why is it all women doing this job? And if we just even throw that question out and just assume that, you know, it just worked out that way and there was nothing improper about the hiring process or recruiting process, it's so often that those employers just assume that we don't have to worry about harassment. But I've dealt with a ton of same-sex discrimination and harassment complaints. So anyway, guy got $300,000. All right. So, and the jury awarded him $451,000, which the judge had to knock down because of statutory limits. And so this was just a construction worker. I mean, this is one construction worker who was harassed by a supervisor because he didn't seem tough enough. So gender stereotype. He wasn't being sexually assaulted. It wasn't quid pro quo. He wasn't, none of that. He was harassed because the supervisor thought he was effeminate and that he didn't meet the gender stereotype. And so, bam, they had to pay out $301,000 plus who knows how much they paid in fees to litigate this thing, and then they're put under supervision for several years to prevent this from happening again, which of course entails costs. So the same-sex stuff, definitely a big deal. Now, I do want to talk a little bit. This is actually a really old court case, but this is an important one. This was the Burlington Industries case, and you've probably heard about this. And this is where the employer was really held liable for the actions of their supervisors, and this is called vicarious liability. And anyway, in this case, it set forth the standard of liability that the employer is responsible for the acts of its supervisors, and employers should be encouraged to prevent harassment. Employees should be encouraged to avoid or limit the harm from harassment. So basically, they established affirmative defenses for an employer. Okay, what can an employer say to protect themselves if this occurs? And basically, the employer has to have exercised reasonable care to prevent and correct promptly any harassing behavior, and that the employee failed to take advantage of that. And so this is what I was talking about earlier, about having that effective complaint process, because that's how that's one of the ways that the employer demonstrates that they took reasonable care. And then if the employee doesn't utilize that, it makes it very, very difficult to litigate. And so when we're really talking about preventing court cases, if that's the employer's big concern, having a really good policy, training on that policy, and having an effective reporting mechanism can provide the employer with a very strong affirmative defense if they do get drug into a lawsuit. A lot of people have asked recently about sexual orientation and gender identity. So two things I want to point out. First, if you do any kind of federal contracts, late last year, the OFCCP, that's the Office of Federal Contractor Compliance Programs, I think I got that right, issued regulations that specifically addressed sexual orientation and gender identity. So if you're a federal contractor, it's specifically addressed by this regulation. But even if you aren't a federal contractor, the EEOC came out a couple of years ago and made it clear that they believe that gender identity and sexual orientation are already protected under Title VII. I used to run across a lot of employers who would say, oh, well, we can harass an employee because of their sexual orientation and gender identity as much as we want because it doesn't say that in Title VII. Now, never mind that 20 or 30-something states had already specifically addressed that and made it illegal. I've felt for a long time that it was already covered by Title VII anyway, because harassing someone because of their sexual orientation is a form of sex discrimination. And that's what the EEOC finally came out and stated relatively clearly for the EEOC, that they believe that it's already protected under Title VII. So there doesn't have to be an amendment to Title VII. The EEOC believes this is within their interpretive authority of the statute, and I think they're correct. So we talked a minute ago about establishing that affirmative defense. So what are the key elements? First, we had to proactively prevent harassment and discrimination. So at a minimum, what should we do? We had to implement a comprehensive policy. If we end up in court and we don't even have an anti-harassment policy, we've got a problem. If we've got a policy that's out of date, doesn't really address all the different forms of harassment, doesn't really lay it out to the employees, we've got a pretty big problem. We want to be able to demonstrate that we trained our employees and our supervisors to recognize harassment, report harassment, to identify when this kind of thing is occurring. We need to show that we had an effective reporting system. Remember, if we have an effective reporting system and an employee doesn't use it, then it makes it very difficult for them to pursue any legal action against us. We can sort of almost get the case thrown out immediately because they didn't utilize that reporting system to let us know that the harassment was taking place. They can't just go straight to a lawyer. They have to work through the company first. And then we need to be able to show that we conducted thorough and impartial investigations, and we had a whole webinar last month about investigations. And then we need to take appropriate corrective action. And that appropriate corrective action is going to depend upon the defense. If it's an old guy like my grandfather used to do, just, not referring to women in the appropriate way, then that is, it's an offense, but we're probably not going to fire him the first time he does that. Now, if he can't stop, then yeah, it eventually could become a major offense. On the flip side, if we have somebody who sexually assaults another employee, we're not going to give that person a verbal warning. First of all, we're going to call the cops, but second, they're going to get fired. We need to make sure that the corrective action is commensurate with the nature of the offense. Here's that anti-harassment policy again, which we looked at segments of this. I've got the sexual orientation and gender identity highlighted here. This is actually right out of our handbook that we utilize with employers who need handbook help. Our anti-harassment policy, as you can see, actually covers all forms of harassment. And then we specifically call out and discuss sexual harassment. We only talked about the sexual harassment portion here. But, it's a pretty good policy. Some companies may want to add to it, but it's pretty comprehensive without being excessively long and full of legalese. And we always want to be careful about that, because if we develop policies that are difficult for employees to understand, then they are not effective policies. And then we look like, doesn't work out so well for us if we end up in court. So a couple minutes shy of my 50-minute mark, but I think that's close enough, so I'd be happy to answer any and all questions. Usually we have quite a few when we talk about sexual harassment, but if not, that's fine too.
All right, thank you very much, Chris. And just as a reminder, if you do have any questions, please enter them in the questions dialog box. The first one we have here is, I have heard from other sources that you cannot tell employees not to discuss with other employees.
No, you really can't. The employers have, since time immemorial, been trying to prevent employees from talking to other employees for a whole variety of reasons. They don't want them discussing workplace policies. They don't want them discussing their wages. They don't want them talking about something that happened in the workplace and spreading gossip. In real life, there's not much you can do about it. You can ask employees to keep something confidential, and if it is of a certain nature, then your ability to enforce that will be greater. You certainly have more control over your managers and supervisors than you do your rank and file employees, but otherwise it's very difficult to actually prevent employees from discussing things, particularly if it happens outside of the workplace. The NLRB in particular, just to give you an example, looks very dimly, this is the National Labor Relations Board, on any kind of employer policies that they believe would prohibit employees from discussing anything that happened in the workplace. And you might say, well, why does the NLRB care about this? Well, if there's harassment going on in the workplace, employees, according to the NLRB, have a right to discuss it because they may want to group together to approach the employer to stop that harassment. And so that's why that employee communication is considered a protected activity under the National Labor Relations Act, ostensibly to protect the ability of employees to form a union. But even if the employees have no intention of forming a union, their right to communicate with each other about their working environment, their wages, their, all of that stuff, their supervisors and managers, is broadly protected by the National Labor Relations Act. So.
Okay. The next question, what does an employer need to do if someone else complains that they heard someone who is not an employee of the company talking down to an employee of the company? And the person says the two work on the same team, but one is an employee of another company and one is an employee of that company.
So you have an obligation to protect your employees from harassment regardless of the source. So if you've got this other company's employee interacting with your employee and they're being harassed, intimidated, discriminated against, whatever, by that other person, you're aware of it, you have to stop it. Now this becomes a huge mess, particularly if it's a customer. We've had to deal with a lot of situations where you had customers who were harassing employees. And, companies, understandably, are very reluctant to go and make a complaint to their customer that one of their, someone who works for them is harassing one of their employees. But your obligation under Title VII is to protect your employee from harassment, wherever it's coming from. So if it's a customer, if it's a vendor, if it's whatever, wherever that's coming from, it's your obligation to protect them from that harassment. So, we'd have to know more about the specific circumstances to render more, specific advice, but your obligation is there. You just have to figure out how to handle it.
Yeah, and the person went on to say, when the employee was asked about it, she didn't want to pursue anything. Does the employer still need to do something?
The employer needs to investigate it, and if they find out that so it just depends on the nature of the behavior. So if let's say that the behavior was just this other person, whoever they were, was just using inappropriate language or speaking disrespectfully or something like that, and they investigate, they talk to their employee says, well, yeah, but it didn't really bother me, and I can work okay with this person, and it's not a huge problem. Then what they would do is they would likely just advise their employee that, hey, you need to let this person know that if their language or the way they're speaking to you is inappropriate, that you want them to change that, and that we're here ready to intervene if this becomes a bigger problem. But if it's something minor, then you may not have to take any major action at this point. Of course, if it was something more serious, then you would have to take action regardless of what your employee thinks. And that's becomes a mess because your employee may not want that. But your obligation to protect them exists regardless.
Okay. Next question, sexual harassment that occurs outside the workplace, is an employer required to investigate that?
Well, if it's off duty outside of the workplace and it has no impact in the workplace, then there may not be anything the employer has to do, but probably the only reason the employer knows about it is because it's having some impact on the workplace. And so if you have an employee who's constantly harassing another employee outside of the workplace and it's impacting their ability to do their job, then it's come into the workplace and you have to do something about it. The fact that the conduct is occurring outside of work doesn't completely take you off the hook. Now, obviously, it does limit your liability because your ability to control that other individual's actions outside of the workplace are severely limited. But if this is something that's become pervasive and it's affecting the ability of the employee who's being harassed to perform their job, then you need to speak with legal counsel and figure out what your options are for dealing with that, because you probably do have some obligation. It's just that your ability to discipline the other employee, the offending employee, for their off-duty conduct is very limited, and that's kind of where you run into a problem. So then the question becomes, what remedies are available to you, and what is the employee who's being harassed willing to do? Because if the employee who's being, so let's say you've got an employee, and this comes up a lot of times, and this is why employers hate it when they have employees who are dating, okay? So you've got an employee who's dating another employee, and so their off-duty conduct would definitely rise to all sorts of Title VII problems, okay? Because they're dating, so they're doing all sorts of things. But they're okay with it right now, so no big deal. They break up, and now you've got one employee complaining that the other employee keeps contacting them or sending them emails or all this other kind of stuff, and your ability to intervene there is very limited. You just have to keep it out of the workplace, and you've got to make sure it's not affecting the ability of the harassed employee to do their job. But once again, your ability to do anything about that is very limited if all of the behavior is occurring off-duty and outside of the workplace. So I know that's not a great answer, but unfortunately, you're kind of in the middle of a situation that you can't easily correct in that kind of a problem.
Okay, and then in terms of sexual harassment training, what is the relation between the number of employees and the frequency of training sessions?
There is none. It just comes down to your tolerance for risk. The longer you spread out, I mean, so if you only do training every 5 years, then you are accepting a higher degree of risk that harassment's going to occur, that it's not going to get reported, and that you're going to end up in court because the employees didn't remember or the employees weren't aware. You hired somebody who never went through training. I think that regardless of size, employers should do it annually. And I know there are a lot of employers who don't want to do that, and that's fine. That's their business. There are lots of ways that you can do the training. It doesn't have to become a big deal. But if you're covered by Title VII, your exposure is the same, okay? So if you've got 15 or more employees, your exposure, you have the same legal obligations as an employer with 15,000 employees. So maybe you're small enough that you think you've got a really good handle on things and nothing's going to go wrong. If so, good for you. But there is no direct correlation. I've seen big companies that never do harassment training and little companies that do it all the time. It really just boils down to your tolerance for risk and your willingness to go through and do the training. You know, there's obviously a cost associated with any type of employee training. It takes time. You may have to buy resources. You may have to, you know, disrupt operations. How are you going to do that? But it all boils down to your tolerance for risk. The more you can demonstrate that you had attempted to prevent harassment from occurring, the stronger position you're in if you end up in court. And training is one of the ways that you demonstrate that you had tried to prevent the harassment.
Okay, well that looks to be like our last question. Just a few housekeeping points before we wrap up. A couple of people have asked for the slides for this session, and we do have those posted on the Client Resource Center, and we'll have the recording, posted there shortly after. As well as some folks have asked about the HRCI credit for this session, and those of you attending this live session, we will be emailing you the code, the program ID for that HRCI credit. So you'll receive that very shortly. With that said, I'd like to wrap up today's session. Thank you very much, Chris, for the presentation, and thank you everyone for joining us today. We hope to see you on our future sessions.